Good morning. This is Rajeshkumar. Today we are going to analyze one problem question in Tort Law, Nuisance, Ryland versus Fletcher. The video content has been made available for informational and educational purpose only. Kindly go through this slide completely. Let's start with the problem question. A cold spring water have operated a sewage management service in the village of Longfield for 2 decades. Fred and Glades have lived in Fir Tree Cottage on the edge of the village for 35 years. In the last 3 years, Cold Spring Sewer have began to overflow into the property in Longfield every spring and autumn. The foul smelling water has destroyed many of the Fred's valuable rose bushes, and at times the couple find it impossible to sit in the garden of Fir Tree Cottage. Many of the residents in their neighborhood have begun to develop physical symptoms in the spring and autumn. Martina is the live-in nanny for the children of the Scott family who live next door to Fred and Gladys. She believes that her migraine headaches are aggravated by exposure to the sewage water. You have to advise the parties. Let's start with each and every issue. In advising Fred, Glades, and other affected parties on the legal recourse they might have against the cold spring water regarding the sewage overflow in Longfield, several key issues of tort law come into play. The issue here primarily involve private and public nuisance, potential liability under Ryland versus Fletcher and negligence. Let's start with the private nuisance. The private nuisance protects an individual right to enjoy their land without interference. Given that the overflow has damaged Fred's roses and impaired the enjoyment of his property, he could argue that CW's action amount to private nuisance. The court evaluate the private nuisance based on interference, unreasonableness, and physical damage. The CW sewage overflow causing the foul odors and damage to plant life likely qualify as substantial interference with the land issue, similar to Bramford versus Turnley and Hunter versus Canary Wharf. Factors such as duration, intensity, and the locality impact the reasonableness. The recurring overflow twice a year for the past 3 years is likely unreasonable by ordinary standards as it disrupts the daily life significantly. The destruction of the Fred's rose falls on the physical damage, strengthening his claim as the courts tend to favor the property damage claims over the cases of discomfort. In other words, the private nuisance require a substantial and unreasonable interference with the use of the enjoyment of the land. In Hunter versus Canary Wharf, 1997 confirms that only those with a proprietary interest in the affected land can sue for nuisance. Fred and Gled's claim they have a strong case for the private nuisance as the owner of the cottage, where the repeated sewage overflow has damaged the Fred's roses and made their gardens unusable during certain seasons. In Bamford versus Turnley in 1862, it was held that recurring smells and the loss of use of the property could constitute actionable nuisance if they substantial and unreasonable. The nature, frequency, and and the duration of the sewage overflow suggest that CW's action might be unreasonable, particularly as they have allowed the situation to persist for 3 years. The smell and the damage to the garden go beyond minor discomfort and significantly impact the couple's enjoyment of their property, aligning with Barr versus Bifa 2012, where long-term odor was found to interfere with the use and the enjoyment of the property. Fred and Glades may be entitled to damages for the loss of the enjoyment and harm to their property. They could also seek an injunction to compel CW to address the overflow issue. However, as seen in Market versus Thames Water in 2003, if CW is considered a statutory authority with the specific remedies available, an injunction may be difficult to obtain, as the court may defer to the statutory compliance procedure. In other words, Fred and Glades may thus seek either damage or an injunction to prevent further sewage spills. However, an injunction likelihoods depend on whether CW's operations are deemed essential to the public and the extent of the community impact. Considering that statutory or public health interest may sometimes override the private nuisance claim. Let's move on to the public nuisance. The public nuisance arises when an activity materially affects the reasonable comfort and the convenience of the class of the people, as outlined in AG versus PYA queries in 1957. Any member of the affected class who suffers the special damage beyond what other experience can claim damages. A property owner suffering the unique damage, the destruction of roses, and the inability to use a garden, they might argue that their injuries go beyond that of the average of the Longfield resident. However, AG versus PYA queries would require that they show the nuisance affects a significant portion of the village. What about Martinez' claim? As a resident indirectly affected by nuisance, Martina may face the difficulties establishing her public nuisance claim unless she demonstrates that her migraines are directly exacerbated by sewage exposure. Qualifying as a special damage, nannies typically lack a proprietary interest and are less likely to satisfy the private nuisance requirement as per Hunter versus Canary Wharf. In other words, the public nuisance addresses actions affecting the health, safety, or the comfort of the general public or a significant group. In Attorney General versus PY Paris, a public nuisance was defined as affecting a high class of Her Majesty's subject. Here, the CW overflow impacts the several residents, leading to the physical symptoms, example, Martineau's migraine. Therefore, the affected residents, including Martina, may claim public nuisance if they demonstrate the particular harm beyond what others in the area experience. Further, the Martinez health concern could also be supported under the public nuisance if the evidence shows her migrants are directly aggravated by the sewages. Yes. Since public nuisance can encompass the community's health risk, the Attorney General or the local authority might take action on behalf of the affected residents. The rules in Ryland versus Fletcher. The rules in this case holds that an occupier can be strictly liable for damages caused by the dangerous thing that escaped from their land and causes harm. To succeed, the four elements must be shown. CW brought or collected the sewage. Sewage is a dangerous thing that, if it escapes, poses a risk. The escape caused damages. The use of the land was non natural. Sewage, the application to the CW. The sewage can be classified as dangerous and its periodic escape suggests failure in containment meeting the escape criterion. However, the Transco versus Stockport MBC case in 2003 clarified that liability under Ryland versus Fletcher requires non-natural use, which may be hard to establish if the CW's sewage management is considered ordinary or essential infrastructure. Further, if the CW operates under statutory authority, the MACIC versus Thames Water indicates that such a claim may be precluded as a liability would interfere with their statutory obligations. In other words, under the Ryland's rule, a liability arises when a person brings something into the land likely to cause harm if it escapes, and it indeed causes such harms upon escape. The rule requires non-natural use, dangerous substance, and escape unharmed. Regarding the non-natural use, the buildings and operating a sewage system could be classified as a non-natural use of the land as it poses inherent risk, similar to the storage of water in Ryland versus Fletcher case. Dangerous substance. A sewage, given its potential to cause environmental health harm, could be considered dangerous if it escapes. Since the sewage overflow has caused property damage and health effects, Fred and Glades and others could have a valid claim if CW cannot prove any differences such as an act of God or third party involvement. In Transco versus Task Part, the court reaffirmed that Rylands versus Fletcher applies only where exceptionally dangerous or mischievous things or kept on land, suggesting that CW's liability hinges on whether the sewage is considered exceptionally dangerous in the context. However, if CW can show that the overflow resulted from an unavoidable incident or statutory requirements limit claims, this claim may not succeed. Let's look into the negligence. The negligence requires proof of a duty, breach, causation, and forcibility of harm. CW as a sewage management provider owes a duty of care to ensure the systems do not harm the residents, health, or the property. Negligence may also be relevant if the CW failed to maintain or upgrade its infrastructure despite knowing the risk of overflows. CW likely owes a duty to maintain its infrastructure to prevent harm to nearby residents. What is a breach? If CW failed to address the known risk or did not follow the industry standards, it could constitute a breach. The continued overflow over the several years may indicate a failure to maintain or the repair the essential infrastructure. In Barrett versus Chelsea and Kennington Hospital case in 1969, forcibility of harm is a critical element. Given that sewage overflow is foreseeable, CW's failure to rectify it might constitute a breach. The causation and damages. Fred, Glades, and Martina could argue that the breach directly caused by the property damage and health issue they experienced. Fred and Glade suffers damages to the property and enjoyment, while Martinez claims health effects. Martina migrants may face causation challenges as proving sewage as a proximity cause might require medical evidences. What are the defenses and remedies? If CW operates under statutory obligations, they may argue immunity from the private nuisance claim as seen in Maukick versus Thames Water, which held that statutory schemes often limit nuisance claims when regulatory frameworks are in the place. CW may argue statutory authority under Maukick versus Thames Water, which held that statutory sewage provides have immunity if they comply with the regulatory framework. If CW has a complaint procedure, residents may need to exhaust it before seeking the legal recourse. Since the nuisance began only 3 years ago, CW is unlikely to claim prescriptions, a long-standing use rights. CW might argue that the resident consented to the occasional inconveniences due to the sewage system by living in the proximity to it, though this would be unlikely to succeed given the severity and the frequency of the issues. What are the remedies? The damages. The friends and others can claim compensation for property damage and personal health impacts. Fred and Glades could seek compensation for the loss of the property use, garden damage, and health impacts. Martina could pursue damages for her migrants if causation is established. What about injunction? Fred and other residents may seek an injunction to stop further overflow. However, this may be denied if CW's operations serves a broader community need or if the regulatory measures suffice to address the compliance. An injunction to prevent future overflow may be difficult to secure if the CW's operations are deemed statutory. However, persistent issues impacting the residents' health and the property may encourage the court to consider an injunction to compel the system upgrade. Let's conclude. Fred, Glides, and Martina have potential claims under the private and public nuisance, Ryland versus Fletcher, and possible negligence. However, the success of these claims may hinge on whether the CW's operation is viewed as essential under the statutory authority or if the alternate dispute mechanism apply. If the sewage management qualifies as statutory, Maukic versus Thames Water suggests that claims for the nuisance under the Human Rights Act may be precluded, thus balancing the individual rights against the community needs. Fred and Glade, the strong claim in private and public nuisance as well as negligence, they are well positioned to claim damages and might seek an injunction if CW overflow continues unabated. About the Martina, the limited resources in the private nuisance due to the lack of proprietary interest, but may claim public nuisance or the negligence if she can demonstrate the sewage exacerbates her migraines. Overall, in the each party, success will depend on whether CW's statutory role limits their liability. Exhausting the internal complaint process might be advisable before pursuing litigation, especially if mark equals Thames Water applies. Thank you.